Good morning, everyone. Good morning from The Hague. It might be good afternoon for you or good evening, but here in The Hague it is still morning. So good morning and thank you for sharing part of your day with us. It is my pleasure to welcome you to the first part of the third day of the Cyber Norms conference. I should say the first panel, because we already had the first part today with a brilliant keynote speech by Maria Rosaria Tadeo. So my name is Els De Busser. I'm Assistant Professor Cybersecurity Governance here at Leiden University. And I'm also part of the research, I'm also part of the Cyber Norms program. For this morning's session, we have 4 papers being presented by 4 speakers. I am sure that you are all familiar with, because all of them have been quite prolific with publishing articles as well as books in this wide field. I will introduce them to you one by one. The common theme of this session is how does international law apply to state behavior in cyberspace, and how, and specifically also where, are the goalposts maybe moving ever so slightly. So our speakers have the arduous task of summarizing their views on this, which they have written down in their papers, into a maximum of 10 minutes. Before I start with the first speaker, I would like to remind everyone listening that we will have plenty of time for questions after all 4 speakers have completed their presentation. But during the presentations, you can already use the chat that you can see on your screen to start typing your questions to have them ready for the Q&A after. Please do not forget to mention your name and professional affiliation, and note that we will not be taking any anonymous questions. Please also indicate whether you would like to address a certain speaker with your question, and keep it short and sweet. If in the meantime or after the session you would like to use social media to let the world know about this conference and about the insights that you've learned today, please use the hashtag CyberNorms2020 or go to our Twitter handle is @HagueCyberNorms. So without further ado, I would like to give the floor to the first speaker of today, Dennis Broeders, who I'm sure doesn't need any introduction anymore, because most of you know that Dennis is a senior fellow to the Cyber Norms program and associate professor here at Leiden University. He will present a paper in which past cyber operations were revisited in light of new cyber norms and interpretations of international law. So Dennis, please, the floor is yours.
Thank you very much. I cannot really see what I am doing, but that's okay. I'm going to try to share my slides. Let's see. And hopefully you can tell me whether that works. Can you see my slides?
Yes, we can.
All right, perfect. Then I'll just head off. Good afternoon, everybody, at least for us here in The Hague. Like Els said, it's a collaborative paper with a number of people here at the Hague Program, one of whom is your moderator for this session. So she's in on this, and we sort of started from the premise that most states agree to the basic fact that international law applies in cyberspace, but the big debate now is, okay, how does it apply in cyberspace? So how do we see this? And one element of this is especially that a whole number of, there I am. Sorry. Hi. One element of this is that especially international law scholars have been egging on a little bit to states to become more explicit in how they see this in real life for international law to be able to move on. So basically, states needed to step up to the plate. So we sort of took this as a point of departure and said, okay, why don't we revisit some of the notorious cyber attacks of the past and look at them through the lens of more recent normative and legal thinking, because in the past few years, we have seen quite a few new sources of normative and legal thinking. We have all kinds of norms proposals from multi-stakeholder groups. We've had national views on the applicability of international law in cyberspace by states. We've seen attribution statements, we've seen submissions of states to the Open Network Working Group, and obviously we've seen a lot of thinking in the academy. And for us, the question sort of was, okay, with all this new thinking, would states, when looking back to those kind of operations, would they have assessed those differently? Would they have had different language to address the nature of a certain attack, the legality, the illegality of an attack? Would they have different language to call it out, etc.? So that was our point of departure. So we took 5 cases. Stuxnet from 2010, the Belgacom espionage case from 2013-2014, the 2015 interference with the power grid in the Ukraine, the election interference in 2016, and the NotPetya attack of 2017. And between the first and the last, you see there's already 7 years, and cyber years count double, I think. And between the first Stuxnet and where we are now, that's 10 years. So there's a lot of things that have happened since that time. So we thought it would be nice to revisit them. I'm going to try to jump through them as quickly as possible. So Stuxnet happened in 2010. And at the time, there was American silence, there was Israeli silence. The Iranians denied that anything bad happened at all. And the attribution to this also came very late. I'm getting an indication that my quality of connection is poor. Is it okay, or? Okay, good, excellent. So what we do know, so the attribution came in 2013 when Iran said, okay, the attackers were the Zionist regime and the American state of Texas. So not very specific still, but no reference to international law whatsoever. And as we also heard in the keynote this morning, it being a very notorious case, it was also prominently in the deliberations about the Talon manual. So they started thinking about this and say, okay, they agreed that Stuxnet amounted to a use of force. They didn't agree whether it amounted to the threshold of an armed attack, but they did say, okay, there doesn't necessarily have to be physical damage or injury in order for a cyber attack to be an internationally wrongful act. So some progress there. The UNGGE of 2015 has a norm protecting national critical infrastructure. So this attack would definitely have flagged that one. And the discussion about the violation of sovereignty also very much related to the Talon manual in the beginning. In the early days was very much about the physical world. So there was debate about whether an agent should be on the ground in order to pass the threshold of a violation of sovereignty. And if we look at much more recent attributions, the use of a breach of sovereignty has become, I think, much lower than that early thinking. The Belgacom hack, where GCHQ and the NSA hacked into Belgium's largest telecom provider for espionage purposes, leaked through Snowden. That's why we know a little bit about it. And at the time, at first, the Belgian government was prone to anger. The UK shrouded itself in silence, and then later, when it became clear that this was not a criminal case, but it became a national security issue, it was a matter of espionage, the Belgians sort of resigned to that, and it sort of petered away, it sort of went away. So the question is, with an espionage case like this, cyber espionage, are there new lines? Are there new lines of normative thresholds? And there is no general prohibition of peacetime cyber espionage. And I'm going to quote one of my esteemed panelists here, François Delerue, who says, okay, there is no general prohibition of cyber espionage, but cyber operations used may breach specific norms of international law. So no blanket refusal, but it can still violate principles of international law. Then the next question becomes, what should that be? Should we think in terms of a damage threshold, and what kind of damage would that be? That would be sort of the Talon manual thinking. Some have been looking into, Corn and Taylor have been looking into a necessity criterion. So was it the best way to do this? Was it absolutely necessary to choose these methods? And someone like Asaf Lubin has been looking at just and unjust causes for espionage operations. And so just causes would be national security, international stability and cooperation. Unjust causes, he gives a few examples, would be election interference or annexation, so hello Russia. Would it be considered a breach of sovereignty? Again, some states are really clear, and if we take, for example, this French position, who has a fairly low bar for a breach of sovereignty, but then very explicitly excludes espionage from that count. So espionage is a a different category in that case. And what you see increasingly is that states are sometimes, or more perhaps than before, calling out acts of cyber espionage, but also opening themselves up to charges of hypocrisy by doing that, because this is a game most states are in. But there's no real legal progress, I would say. Ukrainian power grid attack in 2015. At the time, it was privately attributed by an American company, attributing to Russia, to the Sandworm Group, but there was no real state attribution to this, which is in hindsight a little odd, perhaps. And perhaps it's almost strange to realize that now, but at the time, there was also quite a lot of debate on, okay, are Ukraine and Russia actually in war? And if they are at war, then we need to apply different kind of rules than if they are not. I think by now most people are convinced that they're at least in a conflict. And that would mean that some people have argued, ICRC, Michael Schmid have argued, perhaps this attack could be seen in light of Article 49 of the UN Charter, could be covered under that. If it would have been peacetime, it would probably qualify as a breach of sovereignty by the standards we have now, or non-intervention, and it would also violate the UN GGE norm of 2015. And at the time that this attack happened, basically the ink on that norm was drying still, so it was a very poignant case, but it was not used at that moment. US election interference, interesting case to me. So at the time, we talked about speed this morning with Maria Rosaria. It was a late attribution, and then the repercussions that came were mostly criminal law sanctions. And a lot of people were thinking at the time and later, so if the crime is attacking the democratic system, then is the punishment not a little bit out of sync with what the magnitude of the crime is? And this is one element where you see quite a lot of new thinking and states sort of trying to step up to the plate. We see a number of, mostly Western states, edging towards explicitly flagging non-intervention election interference as a breach of non-intervention. We see multi-stakeholder norms. I'm sure I'm getting. We see multi-stakeholder norms in the Paris Call or the Global Commission flagging this as an issue, although some flag election processes, some flag infrastructure. And we see a number of authors, mostly academics, sort of referring also to the principle of self-determination, either as an add-on or a deepening layer to non-intervention principle, or on its own, as Jens David Olin does. The last one, NotPetya, and there you can already see the difference between 2010 and 2017. So the attribution of the NotPetya attack came fairly fast, first by Ukraine, and sort of hot on its heels done by a broad coalition of states attributing this. Some implicit references to international law and norms, and the US followed on with sanctions, but that was sort of a package deal both for election interference and for NotPetya. So were new lines crossed here? Again, in situation of war, this would perhaps be covered under Article 49, question mark. If it would be war, then you could also open up a discussion about the indiscriminate nature of character of this specific attack. In peacetime, it would probably be a breach of non-intervention, and there is some embryonal work on thinking in terms of norms against the indiscriminate nature of this kind of attacks. And I can see Els frowning. Don't worry, these are my last two slides. So to sum up, so are we inching towards lines in the sand? Is something shifting? I think it's very modest, but there is something moving. Et pour s'y mouvoir. There is a rise of attribution. There's a rise of attribution coalition. They're increasingly calling out fairly modest attacks if you compare them to some of the cases that we've had. So maybe if these cases would re-emerge, you would have a more forceful response. There's some blanket references to international law, some blanket references to norms, sometimes a specific mention to sovereignty and non-intervention, but it's still not very much where we would want to be. We do see a growing repository of state views on how international law applies in cyberspace, but it's not like we're going down the river singing Kumbaya yet. So it gives you convergence on some things, but it also gives you fragmentation on different things, sovereignty being one of the main things. Scholarly impatience, which started this, is still there. State restraint, which started this, is still there. So there's still a need for a better granularity of the normative and legal analysis that we use in these things. So are we raising the stakes? Is the threshold becoming lower to call things out? I think it might be, but when we mix in geopolitics, who do we call out? Who do we not call out? In what kind of language? That still matters. And now I'm going to stop.
Thank you, Dennis, for summarizing the paper and for staying within time constraints also. And thank you for already name dropping the next speaker. So François Delerue can start getting ready and start sharing his screen. So our second paper, written by François Delerue, is a paper that kind of takes a zoom out perspective on state practice and the question whether international law is fading away in state practice on cyber operations. So François Delerue is a research fellow in cyber defense and international law at the Institute for Strategic Research. He was also a fellow in our cyber norms program, so we had the pleasure of having him here for a few days, and he recently published the book Cyber Operations and International Law. So with much pleasure, I now give the floor to you, François. Go ahead.
Good morning or good afternoon, or I don't know if you can see me, and I don't know why I cannot share my screen. I'm sorry for that.
We can see you, but not your PowerPoint.
Wait. It's not allowing me to share my PowerPoint. I don't know why. I'm sorry for that. Okay, I will do it without the PowerPoint, that's fine. Okay. So yeah, good morning. Thank you very much for the kind introduction, and thank you very much for Dennis for already mentioning my work. It was my pleasure actually to present my book in February at the Hague Program on cyber norms, so I really enjoyed that. So my presentation of today is analyzing state practice and state discourse and cyber operation on international law, questioning whether or not international law is actually fading away in their practice and in their discourse. So what we see and what we know first, just to be contextualizing my discussion, is the fact that yes, international law apply in cyberspace, and that has been agreed, and that's today something that is consensual. Actually, it has been agreed by the UNGGE in their report in 2013 and 2015. It was then commented and also accepted by states in their comments to these reports. And it has been also expressed in state views on how international law apply in cyberspace. So today, we don't have any states actually contesting the application of international law in cyberspace. And that's something very important to highlight. Then the question is moving from the question of the applicability to the question of application of international law in cyberspace. And this is, yes, something that I have been working on since quite a long time now. This is the main topic of my book, which was mentioned. But having said that, the question is then, how we have an agreement between states and how international law apply, or is there different approaches? And something that was also already mentioned by Dennis in the previous presentation is actually the fact that, yes, we see some convergence in the views that are expressed, but also some divergence. What is important to recall here is the fact that in some ways we have what we may call a skewed picture of state approach on the international law applicable to cyberspace. What I mean by that is the fact that to date, we have only Western states that have expressed their view, and since the summer we have also Iran, but that's still a very limited group of states. And we don't have a full picture and a full understanding of what will be the specific approach, the specific understanding of all the states in the world. And that's very important to take into account. So yeah, international law apply in cyberspace. We have a consensual approach on that. We may have some divergence on what are specific questions of international law. That, let's say, is a discourse. International law applies, we can identify that. But now we are moving to practice. What is state practice on the international law applicable to cyber operations? Which is something that was already highlighted in the previous presentation. And there we see two types of practice. We may identify two types of practice. State will be operationalizing or applying international law when they are conducting cyber operations. And state will also be applying or operationalizing international law where they are victim of cyber operation and they decide to react to this cyber operation. So these are the two practices I am focusing on in my paper, and I'm analyzing to see how states are using international law. On the first type of practice, state conducting cyber operation, we have a difficulty, I have a difficulty actually to identify how states are actually applying international law because they don't communicate on the actual practice when they conduct cyber operation. So yes, we have military manuals saying that in such circumstances, this is a law that is applicable and this is how we will be applying the law. We have also some comments, but we don't have cases where states say this is a cyber operation we conducted and this is how it is fitting within the international legal framework or also within our military manual. This is something that is a bit different from what we see with physical or kinetic operations, where usually you will see actually a legal review or a legal explanation on what is the basis for the intervention. So that's something that is interesting, but which is challenging for my research. So moving from that, the second type of practice, which is more useful for my research, is attribution, which may be done by states alone where they are victim of cyber operation, or which may be also done by states on behalf of other states which are the victims of the cyber operation, either alone or either as part of coalitions. I am mentioning that some states are actually attributing cyber operation to other states, even if they are not victim, even if the victim has not attributed the case. As French, I would say one of the best examples has been the French elections case, which has never been attributed by France to Russia, but which the US attributed to Russia. And again, recently, 3 weeks ago, with an indictment against a few Russian agents from the GRU. So that's a very interesting case as well. So moving from that, we have 4 types of attributions. The first type will be what we may call attribution by statement. It's when a state is actually naming another state for its responsibility in the conduct of a cyber operation. Attribution by indictment, which is what I just mentioned. And then we have also attribution by alert, which is when a cybersecurity agency from a state will actually issue a cybersecurity alert, which may name a responsible state for the specific threat it is addressing. And I lost, sorry. And then we have attribution by sanction. It's when a state or an entity, because now we have also the European Union taking such sanctions, is taking sanction against a specific actor or state for cyber operations. In all that case, actually international law may be relevant only when you have attribution by press release, when a state is naming another state. Because in the other case, most of the time, actually the target of the attribution is an individual or a group, it's not a state. So it's not an interstate question, and the state may be just mentioned subsequently, but it's not the main focus of the attribution. And the best example of that are the indictments. In the case of the indictment, and we have quite a lot of practice now from the United States, what is interesting is instead of naming a state and then trying to find what will be the international law applicable and what will be the responsibility of the responsible state under international law, you are moving the focus from international law to domestic law and having more criminal case and another type of legal action, which is interesting because then you don't apply international law and you may question why actually going on that path rather than doing an international legal case. Then when we focus on the case where states are naming another state as responsible for cyber operation, I will use a very recent example, the case of Georgia. In February 2020, a group of states decided to attribute a cyber operation against Georgia to Russia. So this case is very interesting because in this case, we have 22 statements by 21 states plus the European Union condemning the cyber operation against Georgia. What is important to highlight here is over 22 statements, only 13 of these statements are actually attributing the case to Russia. The others are just condemning the case. Over these 22 statements, now when we focus on the international legal question, only 11 of them are actually making an explicit reference to international law or the international rule-based order. So that's interesting because over 22 statements, only half of them are actually mentioning international law, which we may wonder why. Some of them, 7 of them actually make a specific reference to norm of responsible behaviors, and 6 of them make a reference to a framework of responsible behavior. I will not detail that here. So this is not an isolated case, and it's what we see in most of cases. Yes, states are attributing cyber operation to other states, but in most of cases, they don't make a specific mention of international law, and they don't apply international law either for the attribution, so identifying what is the international legal framework for the attribution, but also for naming what norms of international law would have been breached, or also mentioning what will be the reaction they will take under international law. And that's a very interesting situation. Having said that, I am wondering, and this is the focus of the paper, I would say this is a question of the paper, why international law is absent in state practice on cyber operation. And I'm making 4 hypotheses, 4 assumptions, which I'm questioning in the paper. The first one is maybe because they consider international law to be still a gray area, an area that is unsure, and they don't feel comfortable or they find it risky actually to refer to such an unsettled set of normal legal framework. Second hypothesis, maybe because they consider international law to be either implicit in their attribution or in their practice, or to be actually granted, so you don't need to refer to it. Third hypothesis, maybe because actually the condemned behavior are lawful, and that's another question we may address. And finally, because they may want to avoid further development of international law. Now, if we take them very briefly, just to answer this hypothesis, no, international law is not a gray area, and as we have seen, there have been a long list of papers, statements from states, and even views that have been published and released publicly that actually explain what are the views of state on this matter. What is also important to highlight is, as I say, we have kind of a skewed picture of what is the views of state, because only a limited group of states have released detailed views on the international law, but there are also those who are attributing most of the cases. So we cannot consider that they don't have a clear picture of what is international law. And the question of being granted or implicit, I think we can say this is not the case, because we see how international law remain at the center of the international discussion on the topic. And then, yes, a lot of cases that have been attributed are actually considered to be lawful under the views of those states. And what is very interesting is what we saw just before, is all this discussion on state sovereignty. Some states don't recognize the violation of sovereignty, and most of the cases of cyber operation will be as a maximum violation of state sovereignty. And finally, and I think this is one of the main reasons, is because they want to avoid further development of international law. Because if you develop state practice, you will be opening the door for further development, or maybe for the development of a specific treaty addressing those questions. So yeah, so that's the 4 hypotheses I want to leave you with, and I'm very happy to continue this discussion over the Q&A. Thank you very much for your attention, and thank you very much for organizing such a great event.
Thank you so much for sharing your views with us. I'm sure there will be more questions coming up soon in the Q&A. But first we turn to our third speaker, to Przemysław Roguski, who can start sharing his screen if he wants to. Yes. So together with Przemysław, we will take another look at norms and law. And we will do that. He will walk us through norm-based accountability versus law-based responsibility for cyber operations. I'm particularly triggered about the word versus, and I hope you will explain to us whether it's a very hard versus or a very soft one. But let me first introduce you. So Przemysław Roguski is a lecturer in law at the Jagiellonian University in Krakow, Poland, and also a former fellow of the Cyber Norms program. So good to see you again, and with pleasure I give the floor to you to present your views.
Thank you, Els, and yeah, good to be back, even if virtually here in The Hague. Those were happier times when we could meet and talk and have a coffee. Anyway, thanks for giving me the floor and for inviting me. I will share my screen and my presentation with you, and I hope you can see that. So the topic of my talk today is norm-based accountability versus law-based responsibility for cyber operations. And in fact, I would like to pick up where François left you with, namely the constatation that when states attribute cyber operations and when states react to cyber operations, there is little talk of international law and responsibility under international law, but rather there is much more talk about accountability for the violation of this ominous framework of responsible state behavior in international, by states in cyberspace. And the purpose of my presentation today is go a little bit into the details of that. So let's first of all look at the language of accountability for violations of the framework of responsible state behavior. Now, you will know that the framework for responsible state behavior consists of norms of responsible behavior and international law, as well as confidence-building measures. However, if we look at the particular aspects at which states are focusing when reacting to malicious cyber operations, we will see that international law, as François has rightly pointed out before, is a little bit on the back burner, let's say that, and states either focus on the whole framework or they focus on the norms of state behavior in particular. And we see that in certain reactions. So for instance, in September 2019, we have the joint statement on advancing responsible state behavior in cyberspace, which was a US-led effort signed by a couple of states, mostly European, which includes a commitment to work together on a voluntary basis to hold states accountable when they act contrary to this framework. And note the word accountability rather than responsibility, which is of importance for lawyers. Then we have certain cyber incidents that François has also mentioned, namely the cyber operation against Georgia, which was attributed by the United States, United Kingdom, and several allies to Russia, but which quite ominously failed to mention the specific norm of international law which has been violated, which leads to lots of questions whether international law was affected at all, or whether we are dealing with a violation of something that is not international law, and if yes, what are the consequences of that? And the last example of that would be on 17th April 2020. Again, the United States, United Kingdom, and other allies condemned the threat of cyber attacks against the Czech healthcare sector. There was no mention of a specific actor who would be responsible for such a threat, but it was made clear that this, if this threat would emanate, that this would violate the framework of responsible state behavior, including non-binding norms. So presumably this alludes to the norm of prohibiting attacks against critical infrastructure, and as a consequence points to holding states accountable for these norms violations. Again, no mention of international law. And this brings me to a conclusion of sorts that states are focusing more on the language of accountability and building up this accountability argument rather than on the language of international responsibility of states, which is the normal parlance of international law and international lawyers. So what does the accountability argument consist of? Well, first, we see that norms and law are amalgamated into a total framework of responsible state behavior in cyberspace, and it is not being differentiated which particular prong of this framework is being violated when we have a malicious cyber operation. In consequence, states are to be held accountable for violations of this particular framework. Instead we see the focus on the framework in general, or more specifically, a focus on specific voluntary and non-binding norms of responsible behavior, for instance, the norm of cyber attacks against critical infrastructure. Now, you may ask yourself, as many lawyers following this discussion do, how can we hold accountable a state for violating something that is non-binding and voluntary in its nature? Because that is the nature of the cyber norms as they have been envisaged by the GGE report in 2015. And the argument that is being put forward by many states, and in many talks I heard officials say that, is that although those norms are non-binding, they should be followed because, and I quote, the UN General Assembly has by consensus called on all states to be guided by these norms. So from the fact that the General Assembly has called on states to be guided in their cyber behavior by these norms, we see the consequence, in consequence, a quasi-obligation to follow those voluntary and non-binding norms with negative consequences if those norms are not being followed, namely with the consequences of sanctions, indictments, public attributions, and so forth, as François has already mentioned. Now, this leads me to my two propositions that I would like to discuss with you. First, my provisional conclusion is that the current cyber deterrence model overemphasized norm-based accountability at the expense of international law. And I think I can refer you to what François has said before. We see a lot of talk about norms. We see less talk about international law. And the second proposition is that this overemphasis on norm-based accountability cannot achieve the intended goal of comprehensively regulating state behavior. Now, why? If we look at and compare the two models for regulating responsible state behavior, one based on cyber norms, which is based on this accountability model I've been presenting, and the other one on international law and responsibility for violations of international law, we see first that they are of a different character. Norms continue to be voluntary and non-binding. The only source of binding legal obligations is international law. And if we compare their function, we also see that they are designed to do different things. Norms are designed to set standards, incentivize good behavior, and broaden the consensus, which may then, if it is broad enough, harden into hard law, hard legal obligations. But at the beginning, we are not there yet. Instead, international law sets the baseline for international behavior. This is the foundational rule that cannot be breached. Now, on cyber norms, we do not have a formal or agreed framework for consequences of breach. What we see as reactions is reactions by states within their own say-so, let's call it like that. Whereas international law has a formalized framework of consequences. If you breach international law, you are obliged to cease, not to repeat, and make reparation. Now, then, if we compare the basis for this enforcement reactions, well, in my view, the basis for enforcing violations of norms that states agreed to be guided by them is quite shaky, because if a state is agreeing to be guided by a voluntary and non-binding norm, then violating this voluntary obligation should not lead to any consequences, because otherwise it would not be voluntary. Whereas in international law, we have a strong basis for enforcement, and the enforcement mechanism. Jurisdiction, if you hold states accountable for international for violations of norms, if you hold states accountable for violations of law, so if you hold them responsible, you have a clear enforcement mechanism, litigation possibilities, and you can resort to countermeasures as a measure of self-help. So what can this overemphasis of norms-based accountability lead to? Well, I would argue that it leads to legal uncertainty. It leads to legal uncertainty because, as we have seen in the context of Georgia or the cyber attacks against the Czech Republic, we do not know what is the basis for assessing the legality or propriety of the behavior or not. We only see that there is ominous reference made to a framework of norms, whereas we do not see whether the behavior was illegal or not. And if it is not illegal, it is still permissible under international law. This may in turn lead to an opposition to the norms framework in general. If states have the feeling that they are being pushed into following a framework which is on its title voluntary and non-binding, and nevertheless, if they do not follow it, they have to face quite severe adverse consequences, this may lead to opposition to norms development in the future and to the general concept of norms. And the last thing, the enforcement mechanisms rests upon a limited justification. It is legally more certain to call out violations of international law and to hold states responsible for that, rather than to enforce or hold accountable and combine with sanctions for violation of something that is non-binding and voluntary. And so, to conclude, what can be done to avoid these negative consequences? Well, I would argue for readjusting the balance between norms and law. And this can be done by strengthening the legal assessment of malicious cyber operations when states are calling them out. So states should name the rules of international law which are being violated, and should justify why certain behavior is nevertheless, condemned, even though it is being seen as legal. So, for instance, as in the case of Georgia. And the second part, use norms as soft standard setters as they were intended to do. The second part is, of course, we need to think about strengthening peaceful conflict resolution mechanisms within the framework of international law. And lastly, we need to strengthen legal enforcement mechanisms. And I think the discussion should move forward on the role and applicability of countermeasures, for instance, for violations of international law. We are a little bit in an impasse on that particular topic. And I think the language of law would need to regain prominence in order to avoid the unwanted consequences that I have been talking about. And with this, I thank you for your attention, and I'm happy to answer any questions that you may. Thank you very much.
Thank you so much for sharing those really interesting insights with us. I'm sure that people will react to that. But first, before we go to the Q&A, we still have a fourth step to make in our reasoning here. And now we are moving the lens to another relevant field, and that's the due diligence in cyberspace. So Jan Lemnitzer is going to walk us through his reasoning on this topic and how the goalposts may be moving in this respect. So Jan is a lecturer at the Department of Digitalization at Copenhagen Business School in Denmark. And Jan, with pleasure, I give the floor to you now, and I hope you can share your screen with us.
Yes. Can you hear me?
We can hear you loud and clear.
Lovely, that's good. Okay, what did this work?
Yes, it is.
Okay, lovely. So thank you very much for having me here. Tremendously enjoyed last year's conference, and I hope we'll be in The Hague next year. In my talk today, I will do something similar as to what Dennis did in the first case, and look at some old cases and see how they relate to recent debates we're having in the field. The only difference is, being a historian, my cases are considerably older. I'm also linking to Przemysław's talk about norms versus laws. And what I'm talking about is that in the specific field of due diligence, we're seeing the opposite move, where what was once a respected law is trying to be turned into a norm in the specific context of cyberspace. So my argument is that there are two major problems with the due diligence debate in cyberspace. First, we have some major states like the United States refusing to commit to a binding due diligence standard as law in cyberspace. Most other states agree that there is a duty of due diligence to prevent one's networks from being used to harm others in a redirected attack. The scope of this duty is entirely unclear. So we have the 2015 GGE report, which is the most precise we have in this field, that has something like universal agreement. And they say due diligence only applies if the attack coming from your territory causes serious adverse consequences, entirely undefined, and you have to take reasonable measures in response, but it doesn't say what they are. It doesn't say whether there is any success requirement for fulfilling the due diligence norm, or whether it just requires you to have an honest attempt. And it doesn't really talk about those states that don't have meaningful, sophisticated cyber capabilities. So can you then just opt out and say, sorry, can't really do anything, or what follows then? That is entirely unclear. Furthermore, there are, in my view, two flawed assumptions regarding due diligence in cyberspace, and they're contradictory, but they're both in the field. The first one is that there is some expectation that states will settle the precise details of due diligence duties in cyberspace by treaty at some point in the future, possibly very near. And there the historian here comes to you and says, this is not going to happen. This is never how due diligence duties were created. Due diligence duties are forged by fire. They are created during or in the aftermath of interstate conflict. That is when states pin down precisely, this is what you should have done to be a responsible member of the community of states. Second, there is another field that argues that for this precise reason, discussion over binding rules in cyberspace is pointless because states will never agree to give themselves new arduous due diligence duties. I think this is correct, but we can challenge the assumption behind it, namely that it would be very, very good to have prepared the ground with solid legal argumentation about which specific due diligence duties in cyberspace might be reasonable, or how they might apply to certain situations, because in a crisis situation, people like ourselves will be called upon to provide meaningful, detailed, and precise advice very, very fast. So I think talking about due diligence is going to be very helpful at that point. And I have brought two very old cases from the laws of neutrality, which I think are the most relevant field of precedents for due diligence in cyberspace. You can look up the details of these cases on Wikipedia, but I'm just going to go straight to the main takeaways. So in the 1872 Alabama arbitration, where the United States and the United Kingdom agreed on an arbitration tribunal to settle the dispute over the havoc caused by a Confederate warship that was built in Britain and then illegally exported and run by the Confederates. The tribunal found that a lack of relevant legislation to prevent this, in this case in the UK, was no excuse whatsoever. And even though the government tried to respond and stop the export of that vessel, that response was delayed, and the tribunal ruled that this delayed response in itself was a due diligence breach. And overall, the tribunal decided that failing to prevent illegal arms exports can create an obligation to pay compensation for the damage caused with these arms in a conflict between other states. So the remarkable thing here is that the UK paid $15.5 million, which in 1872 was a lot of money, even though the dollar was considered a second-rate currency. And crucially, they paid a lot of money for the breach of a duty that did not exist in writing at the time of the offense. It was only put in writing in a treaty which the two sides agreed on for political reasons afterwards. So the lessons for due diligence in cyberspace are here that a lack of legislation is no excuse for inaction or a slow response. So you can argue that this lends weight to existing debates that very soon we will see to have a duty to have relevant cybercrime legislation in place, which dozens of states, especially among developing countries, do not have right now, and that there is a duty to have a CERT team that is trained to a reasonable standard and integrated into the international emergency response networks. Second, while there is no universal legal framework for the export of dual-use surveillance software or cyber weapons, we have the Wassenaar Agreement. Just 2 days ago, the European Union made the rules more restrictive, but there is no global universally accepted law. However, states should expect that a tribunal might, in any future case involving them, very well decide that measures to prevent private companies from exporting powerful software tools to crisis region can be expected from a responsible state, and that this might even trigger compensation payments. The precedents for that argument and the regional arms control arrangements to make that point are already there. Now, coming to my second case, the 1949 Corfu Channel case, which is, as we all know, the very first judgment of the International Court of Justice, and the case that is always cited in the field when we want to show we know where due diligence comes from. Everybody cites this case, but my argument is that we should also read it, and read it very closely, because it has some very interesting aspects to it that are, in my view, often overlooked. So the case is the compensation demand from the United Kingdom against Albania, as 2 UK warships were hit by mines with severe loss of life and a complete destruction of one of the ships when they were conducting an innocent passage through the Corfu Straits, international strait between Greek and Albanian territorial waters. The law of neutrality is involved because at that point the Greek civil war is going on, and Albania and the UK are both neutrals, but they are supporting different sides in that conflict. So the court decided, and that is very relevant for cyber, that even though the mines and the mine laying could not be attributed to Albania, nonetheless, Albania must have known about them being there, and that knowledge alone triggered a due diligence duty to warn other states about the danger of just conducting innocent passage in these waters. So that is very relevant in case of delayed or difficult attribution. When we have no legal remedy to go after an unknown perpetrator, we can have a legal framework that allows us to ask a state through whose networks the attack is routed to stop the attack if it is at all possible, or at least make it more difficult. It also ruled that a subsequent UK minesweeping operation in Albanian waters that was conducted unilaterally was a violation of Albanian sovereignty. Even though in that context it might be understandable that the Royal Navy would want to do that, it was still a violation of sovereignty. And in the end, Albania was ordered to pay almost £1 million in compensation, even though the court explicitly accepted that Albania most likely did not have the capability to lay the mines. So the lessons for due diligence in cyberspace here. The ICJ essentially ruled in 1949 that hackbacks cannot be justified by due diligence failure, parallel with the minesweeping operation, and that due diligence duties do not require attribution to the ultimate perpetrator. So the question is, what duties does the state through whose networks these attacks are routed actually have? Do you have a duty to bring in outside assistance to counter the attack if your own capability is lacking? Second, what is the cyber equivalent of the court's assumption of knowledge about activities in, quote, waters near the coastline. So there would be universal agreement that you cannot be expected to monitor what is happening on every private server registered in your territory, but you can make a reasonable argument that a government should have some idea of what is happening on government IT. And further on, you can make the argument that if you have legislation in place that gives the state special monitoring rights over critical infrastructure and the companies running critical infrastructure, as for example is the case here in Denmark, then this can be turned around and the expectation can be raised that you then have an increased expectation of knowledge of what goes on in these networks. So to conclude this presentation, the main points I want to get across is that from the historical evidence, we can conclude something about the process of the development of due diligence duties in cyberspace. They will be forged by fire. They will be defined in interstate conflict and crisis situations. And if there is a treaty, it will codify accepted state practice. And we may be decades away from that point. So the Hague Conventions on the laws of neutrality codified state practice that was 4 or 5 decades old at that point. The second main argument I want to make is that the classic laws of neutrality, often overlooked because of that decision by the United Nations not to develop this field in 1950, still offer the best structural parallels with the conflict scenarios in cyberspace. And as I've tried to show, these precedents can offer us insights that allow us even to try and predict how cyber due diligence norms will develop and in which direction they will go. And I want to end on the observation that the fact that every single one of the precedents you could try and look at will apply a much harsher standard of due diligence that is currently accepted in cyberspace should give states food for thought. You really don't want to be the state that is paying the compensation payments in the one case that will then be cited for decades as the classic formulation of these duties. Thank you very much.
Thank you very much, Jan, for actually taking a step back into history and using those insights to help the current debate forward. So it's interesting that you mentioned the classic laws of neutrality on your last slide, because I see a very relevant question in the chat that was actually directed to François and Dennis, but I'm sure that you also have some views on that. So I'm going to invite the whole panel to answer this question. And the question is from Sean Cordy from ETH Zurich. How would you revisit former cyber operations and conflicts as per the law of neutrality? Do you see any application or relevance of the law or policy of political or commercial neutrality in cyberspace by states, but also non-governmental actors? So let me first give the floor to Dennis and then we follow the order of speakers. So Dennis, do you have views on this? You're still muted.
I would gladly yield my time for this to people who actually studied this. So I would refer to François or any of the others. So this is not my my area of expertise.
So François.
Yeah, thank you very much for this question. From past cases, I don't see in terms of international law a lot of problem with what we have in place in terms of law of neutrality. So I don't think it's calling from either modifying it or revising it. So we may need more practice also because still we have very limited practice that is applicable to this question. But maybe Jan has more, mainly also on the side, on the private sector side, maybe you have more insights.
Or maybe first we turn to Przemysław. Do you have any views on neutrality in this context?
I would defer to Jan on this. He's the expert on the topic. So I agree with François. I defer to Jan, and yeah.
Okay, Jan, all sides are on you now.
Okay, that's what happens if you write your PhD on 19th century laws of neutrality. One aspect that I think will be very interesting from a historical perspective is to see how this is used. These laws of neutrality are used to establish increased state monitoring duties. So a parallel that you can see if you, for example, look at the Hague Conventions on the laws of neutrality from 1907, is that they very clearly state that if you are a state and you have the duty to stop a foreign army from using your territory to march through and attack another state that is neighboring to you. And you cannot just say, oh, I couldn't have possibly noticed that. And that rule is there because states tried that. States argued, I have a big country, I can't possibly keep up with what happens in the outer regions. And the community of states went down and said, no, you should at least warn the other state about what's going on. Sovereignty comes with the obligation of knowing what happens in your territory and just stopping others from using your territory in a way that harms others. Today we laugh about that. I think in the same way, in a couple of years, we will see much more distinctive duties in the way I've described of monitoring duties of state networks. Especially because cyber attacks are routinely routed through 1, 2, 3, 4 multiple third state jurisdictions, and sometimes use servers there. And so you probably don't have a clear duty if it just passes through your territory very quickly. But if there's, for example, an active server for a DDoS attack or something like that is in your territory, and that is pointed out to you, we might go from not just the duty to take it out, but even some monitoring duties, especially if it's in the networks of your own critical infrastructure. In general, one problem we have here is that when the United Nations was founded, the idea took hold in the International Law Commission that now that we have the Security Council, that in every dispute will decide who is the attacker, who is the victim, who is right and who is wrong, we don't need the institution of neutrality anymore. So there is no need to waste time and effort to update these rules because they are redundant. And I think after many decades of UN and state practice, we can say that that's not precisely how it turned out. So we still have situations where the neutrality is applied. We just have very, very outdated laws. And what I've tried to do is to show that this must not by necessity stop us from applying these cases. With a bit of imagination, it is still possible to look at them and take some inspiration for a norm creation in cyberspace.
Thank you. That was a very clear answer to the question. I see a question here from Jimena Korowska to François, and she's actually highlighting that it's not unique to cyber, that the international community agrees that international law applies in principle, but cannot agree on how. And she's wondering, do you think if there's any other area from which we can learn, in particular, how to nonetheless make progress with regulation? And I might as well group it with the next question by Florian Egloff, also to you, François. Which states do you think will be most likely to be interested in a development of state practice, or are all of them in the same situation?
Yeah, I have already spoke about this kind of issue with Jimena, so I'm not surprised about the question. My view on that would be actually the reverse, in the way that what is interesting in cyberspace is, yes, states have agreed that international law apply, which is something we find in other areas. But then we may wonder why they want now to agree on the details. And that's very interesting. for example, if we take the use of force, when they adopted the UN Charter, they agreed that the use of force is prohibited, but they didn't lose time, let's say, or they didn't spend the rest of the negotiation determining every type of use of force or what would be exactly a use of force. What is interesting in the discussion we see today on cyber is actually they tend to be willing to go into very, very detailed discussion on what would be each type of violation of each norms of cyber, of international law. That's a very interesting evolution. We may wonder why. I don't have any idea yet. Maybe because it's a very challenging and very new domain. The other possibility, it's also because in terms of practice, cyber attacks are something that is happening every day, which is very different from other violations of international law. For example, having a military airplanes from another state crossing your aerial borders is not something happening every day. Having cyber attacks meddling in your servers is something happening every day for states. So maybe they want to find some kind of security and stability in having more detailed understanding and agreements on what is the content of international law. That would be my answer for the first question. For the second question from Florian, I think more or less all states are in the same situation in terms of practice. I think it's kind also of a Pandora box in some way. So no state wants to be the first one to move on that question and start to express what is their practice, what are the legal dimensions of their practice. Because the day you do that, you also open the possibility for contestation. So for now, we still are in kind of a more difficult area to say, yes, you say that your action was justified by this specific norm of international law or this specific rule. But I did agree with you, and this is where I want to go. By remaining on something very abstract on international law and also on norms as it was expressed, I think there is this dimension that you don't open the door for an actual contestation. Last point on that, if I may add, I think where you may have an evolution on that, and that's very interesting and something we saw in the presentations, is the question of espionage. I saw someone made a comment in the Q&A on that, but what is very interesting with cyber espionage is actually you have an evolution in terms of practice because it allows you to do very large-scale espionage operation with very effective effects. So it's not just having someone looking in your trash and taking some papers, it's someone being able to download every single document on your servers. And I tend to think that maybe in the future, it's where you may have an evolution on the approach from states, because they will understand that the consequences are very different from what we had in the past.
Thank you. So you mentioned espionage. I indeed saw a question here on cyber espionage that we might as well take as a next one to stay on the topic. The question comes from Alexander Buehler from Leiden University, is directed to both François and to Przemysław. Cyber espionage differs in many ways from traditional espionage. So let me summarize the question here a bit. Should cyber espionage be considered equal to traditional espionage in international law? Should it be considered as a use of force, given the severity of its consequences? Or should states push for a legal framework adapted to cyber espionage? I can imagine that many panelists have a view on that. Let's first turn to François and to Przemysław. Who wants to take this question first?
I can go first, if that's okay. So, yeah, a great question about cyber espionage. So on the first comment on use of force, I would say no. For the use of force to apply, we would need to pass a high threshold of scale and effects, which are comparable to the use of armed force. And you don't see that with any kind of espionage. Once something blows up, it stops being espionage, it starts being use of force. So that's a clear no. However, on regulating the framework, Yeah, the problem is the following. If you look at how states obtain information, it's been done in two ways, essentially, through cyber means. First, they are accessing internet access nodes in order to filter information. So mostly, if you have an internet access node in your own country, you can install filters, you can sift out everything that goes through, and then just go through that. And this is what the Germans are doing, what the Americans are doing, what everybody basically with a big internet access point is doing. The other thing is, of course, you go into foreign networks and you take the information from there. So for instance, you go to the German Bundestag and you hack the account and you download gigabytes of data from the German Bundestag. And the question, of course, then becomes, well, how is this regulated by international law? And the answer is, unfortunately, it is not quite obvious. The problem being that many states are holding the position that espionage as such is not regulated by international law. It is neither prohibited nor is it expressly allowed. It is a gray area which is not particularly regulated. However, certain means of espionage can violate certain rules of international law. And one rule that is being argued that could be violated is the rule of sovereignty, if such a rule exists, because we have this big debate about that. So I would say that if you follow the French and Iranian approach, the consequence to that would be that any penetration of a foreign network which violates the confidentiality, integrity, or availability of data on that network would violate the rule of sovereignty. And in consequence, any cyber espionage operation doing that would violate this particular rule. However, we only have France and Iran so far arguing that. My hunch is that the opposition to the penetration-based approach is precisely because of its consequences for cyber espionage. States do not want for cyber espionage to be legally prohibited under this framework. Thereby, either they deny the applicability of sovereignty in cyberspace altogether, or they go for a more effects-based approach. So you would look at the effects for instance, data, financial services, and so forth that would be produced by a violation of sovereignty. And you can see that also, for instance, when you look at what behavior states are calling out. So, for instance, if you take a look at months ago, Australia called out, well, it didn't name China, but it was quite obvious that it was China who was conducting a persistent campaign into Australian networks. Now, Australia did not name China, and it did not say that it violated any rules of international law. Why? Well, because Australia is also in the camp of not saying that sovereignty, that penetration, breach of confidentiality, integrity, or availability of systems is a breach of a rule of international law. Or take a look at the US. The US is trying a very different approach. It is trying to say cyber espionage into healthcare facilities, into, for instance, COVID research, that violates a norm, again, protecting critical infrastructure, but it does not violate law as such. And this goes to my presentation. So to sum up the answer, I would advocate for a more robust legal framework on espionage, but the views are so divergent. The US is so strongly against that we will not see anything in a legal way presented in the near future. And if you look at the scholarship, if you look, for instance, at what Asaf Lubin writes or people like that, they are strongly of the view that espionage as such is permissible, and they are trying to qualify that with impermissible targets of espionage. Now, to me, that is a little bit frustrating approach. It would be much clearer to adopt the French position and just go for it. But to be a little bit critical of the French as well, they expressly in their document stated that this document does not state anything about cyber espionage. So we don't know whether their penetration-based approach would be different for cyber espionage or not.
Thank you. I think that's a call to you, François, to explain the French position on espionage.
Yeah, I cannot really go on that. I'm sorry, since I'm working for the Ministry of Defense. But what I would say here on my approach on this question, what will be for me the important point is when we have this discussion about espionage, and this is my own view, is we tend to take into account the intent or the purpose of the cyber operation, which is something that usually we don't take into account when we apply international law. So that's very interesting, because that will be a very different practice, a very different approach to actually what we have been doing in the past to different situations where we have had to apply international law. So that will be my main comment on espionage and on these whole questions is, to me, and I think this was also what Przemysław said, is international law apply to cyber espionage operation that is applied to other operations. And then the question of if it's a cyber espionage operation or if it's something else will be taken into account, not for qualifying its lawfulness, but whether or not the state will call up for the violation of the rule or principle of international law that has been breached. So I think this is where you have a distinction to make rather than the legal point. It's more on the political side of what will be the action of the victim state.
Thank you. Oh, yeah, Dennis, please.
Just a short comment, and not so much based on law, international law, but more one of the reasons I think we're having this debate is because of the increasingly blurred line between what is a military activity and what is an espionage activity. I think that is one of the core reasons this debate keeps resurfacing. For example, at some point here, we did a workshop with a lot of Intel people, and we started sort of scoring different kind of operations that were done by intelligence agencies, and even the people, these were all ex-Intel people, and even they, quite a lot of those operations, they would say that's not actually permissible within what we should be able to do. So even within that community themselves, they are also sort of working on the assumption, okay, so how far does our brief go? What do we do? When do we hand over to the military? And like Przemysław says, at some point, if you cross the damage threshold, then it ceases to be an Intel operation and it becomes something else because it's damaged and then you violate a norm, but it will still be the same people behind the keyboard. So the law says, okay, it's the state that it eventually does something, but internally and also in looking at what other states are doing, there is a lot of ideas on okay, how does the work they are doing, how does that still fit with their brief? And I think that's a lot of where this comes from, but it's not a legal comment.
Yeah.
Okay, also not a legal comment, but building on Dennis's point, in the build-up of offensive cyber capabilities of a lot of states, they start with what they have, and what they have is usually within intelligence or military intelligence. So very often you have structures like, for example, here in Denmark, where the offensive cyber capabilities of military intelligence are massively expanded and are told to essentially be available to the military if needed, without saying for what and under what circumstances. And it creates a real chain of command problem. And if you are then a military lawyer who's supposed to tell people what is espionage, what is war, who can order what to whom in what circumstances, you have very, very little to build on. And I think that is one reason why states want clarity, while at the same time they don't really want to tell us for what kind of operation.
Thank you for all sharing your insights with us. And I think that the same goes for the next question, because it's quite a broad question to all speakers. It's a question by Russell Buchan. So about principles of sovereignty, non-intervention, non-use of force, and due diligence. So his point is these principles, we must interpret these in a conceptually coherent way. And this means that state practice doesn't exclusively dictate the content of these principles. The content comes from the principle sovereignty, intervention, coercion, force, etc. So his point is to see the principles as principles that have freedom to evolve, not as raw expressions of state practice. and it must be interpreted strictly in line and as a reaction to state practice. So the question is, do you agree, and what are your insights here? Shall we follow the lineup of speakers and start with Dennis?
Sure, I'm not sure I will be the most profound voice on this, but I've always been fascinated by sort of so you have the institution of international law, and then you have the legal profession or legal scholars developing part of it, and then you have state practice developing part of it, and that is sort of like a triangle. And to me, it's not entirely sure how that triangle works, and I guess it differs in certain cases, and it differs in time. What I have seen sort of in going through when we were writing the paper is sort of the academic impatience that I saw at some point, and it went two directions. So one was the direction, okay, states need to step up to the plate and make clear what they think it is, and other legal scholars who say no, there is a so similar to Russell's point, say okay, no, some of these principles have already been named. And it's not necessarily up to states just to change them according to how they want. There is a whole building of knowledge and interpretation that has to be taken into account. So it is between those two factors. But it's a really good question. I would really like to hear what the others have to say about this.
Me too. So I give the floor to François.
Yes, thank you very much. Yeah, it's very interesting, and it's a very important question for what we are doing with international law. My comment here would be the main issue with those principles and the rules that are deriving from those principles most of the time is they are very general. So yes, they exist. They are defined in some ways, but then you have a lot of leeways for states in the interpretation of these rules. So that's where I think it's a more complicated question than what we would have with a body of rules and principles that will be more defined and more tailor-made to what we are talking about. So for instance, if you take sovereignty, yes, states should not violate the territorial sovereignty of another state, that's quite clear, but still you need to understand what is sovereignty, and it's defined in other area. It's still open to some kind of interpretation and some divergent approach in cyberspace. So I think it's where it's very important to understand this distinction. So for me, in most of the situation, it's not really that states will be contesting the existence or the applicability or the application of the principle and the related norms. It's more that there is still some rooms for interpretation and for having their own interpretation. The only exception on that, I would say, is still the question of sovereignty with what did the UK with their very specific approach, where they say they don't consider there might be violation of territorial sovereignty in cyberspace. This is very interesting, and this is a very distinct approach to what I have been mentioning before. So yeah, state practice is important. But yeah, it should be complying with existing understanding of the rules or principle. Still, and this was also mentioned in another question, state practice is to be taken into account in the, let's say, in the future to understand what is the content of the norm. And this is really something that is used to understand what is the interpretation of the norms.
Thank you. Przemysław, your view on the principles.
Yeah, thanks, Russell. Great question. So I would agree with you totally. I think that, you know, international law and those principles need to be interpreted within the whole body of international law, which is a system that is not, you know, just confined to certain norms that are independent of each other, but that interact, and we need to take a look at that from this point of view. And I think we are beginning at least to look at that from this point of view. If we look, for instance, at the at recent state practice, at recent declarations of states on the question of how international law applies to cyberspace, we would see, for instance, that the Czech Republic made a similar comment in February, pointing to ICJ jurisprudence, saying effectively that, you know, we need to interpret principles of international law within the whole body of applicable rules and principles. And I think the first statement that tries to build a doctrinally comprehensive approach to the applicability of international law to cyberspace was the recent Finnish declaration that was published a month ago or something, because they set out from sovereignty as the basis of most things that are important in international law, and they derive from that certain obligations pertaining to the other aspects, like territorial sovereignty, like due diligence, like intervention, and so forth. So I would welcome if states go more into the Finnish route, and the French as well, and the Czech, rather than just stating what we think and we don't think on the basis of giving cases, which are also important, but I would welcome a theoretical approach more than that. Now, one final comment, which may, at least to me, be one of the explanations why we see this fragmented approach. And I think this has to do a little bit with the different schools of international law that are at work here. So if we look at the common law approach, this is very inductive based, right? They are looking at the development of international law through state practice rather than deducting certain things from first principles. And if we look at the continental schools, and continental lawyers have a very different approach. We take the sovereignty and we try to deduct what this means for certain rules and applications of that rules to cyberspace. So this may also explain a little bit differing approaches. At least this is how I read certain American scholars on this particular issue. It's very practice-oriented, building from the bottom up rather than taking it from the top down.
Thank you. Jan?
Right. I would say this is one of the reasons why I've picked due diligence, because it is one case where we have a very clear but very broad principle that you can trace back to Roman law if you want to. Basically, your territory should not be the source of harm to others, either through action or omission. But what that means in detail is then essentially negotiated between states. If you look at it from a historical point of view, what comes in is an expectation of what a state should be able to do in the territory for which it claims sovereignty. So it's sovereignty turned around. You say this is your territory, it should not be violated, this is yours exclusively. So if it is abused by others to harm third states, that implies a duty. And it doesn't apply a complete absolute duty. But states are calling each other out for what they think is a failure to do the reasonable thing. And what the reasonable thing is negotiated and changes over time. So the bureaucratic capabilities of a state to know what's happening in its territory and to take action in the 1820s are completely different from what they are in the 1890s. And the law develops with that. And I think we are at the point where states will begin to call each other out and say, look, it's not 2010 anymore. You should have some idea of what's happening in your cyberspace, and you should have some very well established means of responding to that and interacting with others in this sphere to prevent harm to others. That because of this interplay between sort of reasonable arguments, practical arguments, and the broader theoretical principled framework of why states have to do this, that's why I think due diligence is a particularly interesting and relevant reason for this kind of norm development in cyberspace.
Yes, François?
Yeah, I wanted just to add 2 points on that. First, a very general comment, but I think one of the reasons also of this question and of this issue is something very known, but the fact that yes, we don't have a central body of jurisdiction in international laws that will actually answer these questions. So everything is up to argumentation between the states. So at some point they can express their views, but there will be no jurisdiction or nobody that will say, oh, actually you are wrong, and this is the exact interpretation you should have, and this is what should be your understanding. So there is also, I would say, in some way, kind of a race for some states to express their view and kind of shape what would be their understanding and what would be the interpretation of specific rules. And I think on that, what we see on espionage is very, very telling. My second point on that, I think one of the issues we are facing is also the fact that cyberspace is really challenging for the organization of our states, in the way that we are now needing to apply specific sets of norms and principles of international laws that before were applied by different ministries and agencies. So for example, if we talk about the reaction to cyber operations, self-defense was a competency of the Ministry of Defense in conjunction usually with the head of the state and with the MFA. Countermeasure was something that was more applied by Ministry of Budget or Treasury or something else. So we have very different practice, and we are now with a situation with cyberspace in a need to have a coherent approach to all these different practices that were not that related in the past, I would say. And this is also why we still need to have this work on connecting those different questions.
Thank you. And questions is really the key word here, because I see so many more questions in the chat that I would love to ask you, but I'm afraid that we're running out of time. So I would invite you to maybe get in touch. I would invite all the question askers to maybe get in touch with the speakers to clarify these points. But in the meantime, I really want to send a warm thank you to all our speakers, to our panelists, for giving very thorough answers, but still very precise and concise. You are very well sticking to the time limits, and I think we all learned a lot, and we can now go into our lunch break with a lot of food for thought. And I would be happy to see every single one of you online now, again at 2 o'clock, when we reconvene for panel 6 toward inclusion, the global governance of cyber norms, moderated by Tatiana Tropina. And with that, I leave all of you, and I thank you all for your interaction.